Getting Legal Protection from Abuse. Video 6, How to Present a Case, Witnesses and Exhibits. You have the right to protect yourself from abuse. This video, the 6th part in the series, Getting Legal Protection from Abuse, will explain how you can present your civil protection order or CPO case, including questioning witnesses and introducing exhibits. You may be nervous about your court case. For support, you can bring a victim advocate to court with you during your hearing. The advocate cannot speak, but can be a comforting presence. It's important to prepare before giving your testimony to a judge. Sometimes the judge will ask questions at the beginning of the trial. When answering the judge, be sure to make eye contact. Be respectful. Refer to the judge as Your Honor. In Video 5, we discussed the legal standard. Be sure to describe the acts of domestic violence and your continued fear of harm. When giving testimony, tell the court your name and your relationship to the respondent, your abuser. Tell the court what happened that led you to come to court to ask for the protection. Start with the most recent incidents and work backward in time to cover all the incidents in your prepared timeline. Next, be sure to explain the remedies you are asking for. Remember, the remedies are specific actions the respondent must do or not do. These may include the number of years you want the order to be in place. The maximum is 5 years. If you want exclusive use of your shared home, who you want protected, you, your children. Do you want temporary custody of your children, financial support, use of a marital car, the ability to talk about parenting issues with the abuser. Video 5 talked about preparing your witnesses. While questioning your witnesses in court, ask them to provide their name and to explain how they know you and the respondent. When you question your own witnesses, this is called direct examination. On direct examination, you are generally only allowed to ask open-ended questions. An example of an open-ended question would be, what did you see on September 29, 2022? As you continue questioning, it's a good idea to ask your witness where they were on a particular day or what they were doing so you can establish how they know the information you want them to provide. Ask them to tell you the story of what they saw or heard from the respondent. Who was involved in the incident? Who else was present? When did it happen? What did they see? Where did it happen? Were the children present? Remember, a witness cannot talk about what someone else said. However, your witnesses can testify to what the respondent said, just like the respondent's witnesses can testify to what you said. After you finish asking the witnesses your questions, the other side will ask the same witnesses their own questions. This is called cross-examination. You are also allowed to cross-examine the respondent's witnesses. Cross-examination is used to raise doubts about the other side's witnesses and their credibility or truthfulness. Cross-examination questions should be straightforward and should be able to be answered in a one-word yes or no response. An exhibit is any document, record, or other object that can be introduced as evidence in court. If your exhibit is a photograph or text message on your phone, you should screenshot it and make sure to print it out. A judge will not usually look at your phone. It's helpful if any photos or text show the date and time they took place. You should also make enough copies of each item so that the judge, the opposing party, yourself, and any court reporter can get to the document at the same time. When you're ready to present your exhibit, your first step will be to ask the judge if you can show it to the witness. The judge will then either allow you to approach the witness and hand them the exhibit, or if there's a bailiff, the judge may have the bailiff hand it to the witness for you. Once the witness has received the exhibit, you will ask them to describe it and where it came from. You will also want to authenticate or verify the exhibit by asking if it is a fair and accurate representation of what is meant to show. Once you have presented all exhibits, you can ask that the judge admit them into evidence. At that point, the opposing party will have the opportunity to ask questions about the authenticity of the evidence and object to the evidence being admitted if there's a reason to do so. If the judge accepts the evidence, it will then be admitted into evidence, and you can ask questions about it to anyone you call as a witness. While it's always best to consult a lawyer, especially if you have children or shared finances with the abuser, this video series, Getting Legal Protection from Abuse, will take you step by step through the process of getting a civil protection order, including how to request help and special accommodations, what to ask for to keep you safe, how to prepare for court, how to present your case, and how to enforce your protection order. Everyone has the right to live free from domestic violence. For more information on protecting yourself and your family, contact your local domestic violence agency. To find your local agency, contact Ohio Domestic Violence Network at www.odvn.org/find-help. You can also contact your local legal aid. To find the legal aid for your county, contact www.ohiolegalhelp.org/find-your-legal-aid. Or if you are in Northwest or West Central Ohio, contact Legal Aid of Western Ohio at 888-534-1432.